So, let me tell you this story. It's about how one person, a state law, and what seems like a simple $50 fee ended up sparking this huge fight that, believe it or not, changed the rules for absolutely everyone.
Let me ask you something. How much should it really cost to get a copy of, say, a public court recording? It sounds like a pretty simple question, right? Well, in this case, that one little question kicked off a whole legal battle about transparency, about fairness, and really about what the law even means.
And for a while in Johnson County, Kansas, the answer was exactly $50. $50. Clean, simple, easy. But here's the thing we're about to dive into. Simple and legal? Yeah. They're not always the same thing.
Okay, so first up, let's break down the policy that got this whole ball rolling, the $50 flat fee. What exactly was it, and why did they even have it in the first place?
So this is the actual wording right from the court's administrative order back in April 2023. And look at that phrasing, a flat fee of $50. That's super specific, right? No variables, no itemized list of costs, just one single price for everyone, no matter what.
You know, the idea behind it was probably convenience, I get it. You know exactly what you're going to pay right from the start, no surprises. The problem is, this super convenient flat fee was on a collision course with a state law that had a very different idea about how things should work.
And that collision? Well, that brings us right to the heart of this whole thing, the actual cost challenge. This is the moment where one citizen basically stood up and asked a question that's kind of a big deal. Hey, can a local court just make up a rule that completely ignores state law?
So the legal tool they used in this fight was something called the Kansas Open Records Act, or KORA for short. And you got to understand, KORA is a really big deal. It's the state law that guarantees the public has a right to access government records. We're talking everything from city council meeting notes to, yep, you guessed it, court recordings. And get this, the person who filed this lawsuit wasn't some fancy lawyer from a big firm. Nope. It was a citizen, a guy named Lonnie LuPardus, and he did it pro se. That's just a legal term that means he represented himself. No lawyer, just one guy taking on the whole system. Pretty amazing, right?
Okay, so this slide really boils it all down. On one side, you've got the court's rule, $50 flat fee. Simple. On the other side, you've got the actual state law, KORA, which says, nope, you can only charge the actual cost it takes to get someone that record. The whole lawsuit was built on this idea that you can't have both. They completely contradict each other.
The argument in the lawsuit was really straightforward. First, a flat fee just isn't the same thing as an actual cost. It's more of an estimate, right? And it could be illegally bundling in other expenses, like, I don't know, general office overhead. But here's the real kicker. When the court was asked to show its math to prove how they got to $50, they had nothing, no documents, no justification. Oof. And this is where the story takes a really sharp turn. You might expect a long, drawn-out legal battle, but that's not what happened. Faced with this lawsuit, the court didn't dig in for a fight. Instead, it changed course. And it did it fast. Like, really fast. Just look at this timeline. It's pretty wild. The lawsuit gets filed on January 6th. And then, boom, a little over a month later, February 17th, the court doesn't just edit the policy, they throw the whole thing out and issue a brand new one. That's a huge move. 42 days. That's all it took. In the legal world, that's basically light speed. This filing stamp right here shows the exact date the new order went into effect, and it really underscores just how much of a direct impact that lawsuit had. And this wasn't just them playing with words, the change was huge. The phrase flat fee is gone, completely erased. Now it's a $50 deposit. And the key part is that the final bill would be the actual cost charged against that deposit. So if it costs less, you'd presumably get money back. Just like that, they changed the policy to match the state law they were being sued over. So, story over, right? The policy got changed, big win for the little guy. Well, sort of. It was definitely a win, but the new rule actually raised a whole new set of questions about what the price of public access really is. Because, let's be real, just swapping the word fee for deposit doesn't magically fix everything. And as this note points out, people realized right away that there were still some pretty big unanswered questions left hanging in the air.
For example, what about all the people who already paid the $50? If the actual cost was only, say, $10, are they owed a refund? And how is the court even going to calculate this actual cost from now on to prove it's fair? The new policy also says they can waive fees over the deposit, but what if the cost is way under? These are the kinds of questions that are still out there.
And that's really the main takeaway here. This whole thing was never really about just $50. It was about a much bigger idea, that when you ask for public information, you should pay what it actually costs to get it to you, not some arbitrary number that could stop regular citizens or journalists from being able to hold the government accountable.
So, it all leaves us with this one final thought. Sure, a flat fee might be easy and convenient for the government agency. But if that fee doesn't reflect the true cost, who's actually paying the price for that convenience? That's the real tension here, and it gets right to the heart of what an open government is supposed to be all about.